2004. Justice Dhulia was elevated from bar to the bench and appointed as judge of Uttarakhand High Court in 1st November 2008. On 10th January 21, he became the Chief Justice of Guwahati High Court. Thereafter, on 9th May 22, he was elevated as the judge of Supreme Court of India. Justice Dhulia, please.
So you don't mind if I speak from here? Because I'm not at all in a speech mode or speech mood, whatever you call it. Dr. Rana, Dr. Sharma, distinguished audience, ladies and gentlemen. See, as I've said, I came here more to know about what's going on in the arbitration field. You wrongly said it as a keynote address. Please don't take it as a keynote address. There were two reasons I came. One was because I was pressed into it by my very old friend Deepak Dhawan, who was an Indian lawyer. He was Purana Bachpan ka dost kind of a thing in Allahabad. And so I couldn't say no to him. He was a very bright student and helped me in law also. So for this I couldn't. And he chose executive officer being in Indian Oil, then IS Allied. He left IS Allied and come. So he used to be quite bright. हमको बताते थे law में ऐसा ऐसा ये पढ़ लो. So I am returning the favors to him in a way. Even though I'll be very embarrassed if you ask him any question on the subject. See, my take on this is that in India we have a very long tradition of arbitration. The word arbitration in different form is mentioned in our ancient texts, in various forms. It was being practiced everywhere. We have, all of us have got long, interesting stories of arbitration among the family. Famous story of Premchand, Panch Parmeshwar. It's an arbitration. It's an arbitration being done in a village, and which he says, when you sit on the seat of an arbitrator, you are like God. You're doing the same thing as was supposed to be done by the Almighty. So nothing like a past enmity or friendship will count once you are an arbitrator. Therefore, when we speak about arbitration, nobody is teaching us anything new. You know, Indian society, Indian culture, we're all geared to it. And the main reason why arbitration was being preferred to the normal litigation was that the foundation of arbitration is, to my mind, is equity. If you go for courts, then it is law. And one thing I don't understand here also, that in the Arbitration Act 1996, there is a equity clause. If you read section 28, and nobody refers to it, nobody uses it, which seems to me quite strange. Section 28 of the Arbitration Act says rules applicable to substance of dispute, and subsection 2 says the arbitral tribunal shall decide ex equo et bono or as amiable compositor only if the parties have expressly authorized it to do so. In other words, the arbitrator can decide, they can say no rules, no CPC, no evidence, nothing. You just leave it to me, trust me, and I'll give it to you. Then it will be easily done, it will be very speedily done, but in that case, both the parties have to agree to it. Once I asked a question to a lawyer who was doing a lot of litigation in arbitration, and he said, sir, it's very obvious why we don't do it. So I leave it to that, but I think this is a provision which should be looked into, which should be exercised more often if you want a speedy and quick justice in arbitration as well. Because the main purpose of arbitration was that the justice and the dispute be resolved speedily. But is it happening? Look, I was looking at Section 11 jurisdiction when I was a judge in Uttarakhand High Court for 3-4 years. And disputes which were coming to me for 4-5 years, there was no reference also, like we have in the Section 8. Kuch hota hi nahi tha. And Section 11, they keep on fighting for that also. Then later on in the arbitration matter, 10 years, 14 years, 15, arbitration which has been referred in the old Arbitration Act 1940 was still alive in some manners. So I'll just read a very interesting uh, observations of Supreme Court, which has been done by Justice Desai. This is D.A. Desai, and I'm sure you are aware of it. He said about arbitration, says, interminable, time-consuming, complex and expensive court procedures implied jurists to search for an alternative forum, less formal, more effective, and speedy for resolution of disputes, avoiding procedural claptrap, and this led to Arbitration Act 1940, so 1948. However, the way in which the proceedings under the Act are conducted, and without an exception challenged in courts, has made lawyers laugh and legal philosophers weep. And of course, the parties also weep. Experience shows and law reports bear ample testimony that the proceedings in the Act have become highly technical, accompanied by unending prolixity at every stage, providing a legal trap to the very informal forum chosen by the parties for expeditious disposal of the dispute has, by the decision of the courts, been clothed with legalese of unforeseeable complexity. And this is a reality, even if the judgment speaks of 1940 Act, I'm sure it's equally applicable to the 1996 Act as well. You see, I do not know, sometimes the arbitration proceedings are also referred to as alternative dispute resolution. How is it an alternative dispute resolution? Once you bring courts into it, section 34, section 11, section 34, 9, 37, and then of course the Supreme Court is there. How can it be like that? So something has to be done. I mean, I really don't know, because and changes keep on coming. Because since we were just discussing it, why so many amendments and why so many changes? Because let us accept it. Arbitration finally is a rich man's litigation. The poor people don't go for arbitration. And rich people, being also very influential people, can raise their grievances more easily. Therefore, if there is a slight difficulty with the Act, amendments are brought in. How many amendments have been brought in the Workmen Compensation Act, or the Zamindari Abolition Act, or Payment of Compensation Act? Acts which actually are for the poor, which also need such amendments. So one reason for being complex, time consuming, is also because there are courts involved in it, there are smart lawyers involved in it. I don't never underestimate the intelligence of the lawyer. They will make out a point in any case, and therefore the dispute remains alive. So something has been said about this new circular also, which is come. See, I've gone through the circular. I think the government, a lot of pain is reflected in that circular, because after all, experience also shows that many of the decisions were also going against the government. Maybe they were not represented, maybe whatever is happening. And then one of the reasons cited in the circular is that one of the essential conditions, one of the essential purpose of arbitration was speedy disposal. That is not happening. And there is a reference being made in that of the reason assigned is that one of the reasons cited is the process of arbitration itself takes a long time and it is not as quick as envisaged, besides being very expensive too.